Hi, my name is Ian Wu. I'm an attorney at Goye Ruano Thompson. I've been with the firm for 3 years now, and today I will be talking to you about conviction disclosure for RNs. Disclosure and conviction disclosure is a very important aspect of an RN's career. When an RN suffers a conviction, that conviction must be reported to the Board of Nursing within 30 days of that conviction occurring. If the licensee fails to disclose within 30 days, they could be subject to additional discipline. But that disclosure is the opportunity for that licensee to come forward and explain to the board exactly what happened during this conviction. Now, with disclosure in conviction cases, most of the time we're dealing with driving under the influence cases. And when we disclose driving under the influence cases, what we want to do is essentially provide the board with, of course, case numbers, dates, sentencing orders, but we also want to show the board that the licensee who's been convicted is complying with the terms of their criminal sentencing orders, such as DUI school or going to the MADD program or having an ignition interlock device installed. So we want to show the board that you're complying with the court's orders, and we want to show them rehabilitation efforts. And the reason we're doing this is because we want the board to issue you something that's not formal discipline. If the board decides to issue you formal discipline, what they'll do is they'll file what we call an accusation against your license, and they'll serve that to you in the mail. Now, the accusation will call for the suspension or revocation of your license, but the board will allow you to enter into settlement negotiations or go to a hearing before an administrative law judge to present your case. Regardless of the settlement negotiations or going to hearing, if any discipline is enacted on your license from an accusation, that discipline will remain on your license publicly and indefinitely. So it will be viewable on the Breeze website or the Department of Consumer Affairs website, which is something that many licensees hope to avoid, as it hinders their employment. It's not something that people want to be seen publicly. So the disclosure process is pretty important for getting your explanation out there to the board, showing the board that you've been complying with what the court's been ordering, and to show them that you're not a threat to the public, in hopes that they do not file this accusation. In lieu of an accusation, the board might issue a warning. They might issue you a citation and fine, which is not included in formal discipline, but is an internally kept document, which does not show up publicly. The accusation process is long and tedious. There is a lot of moving parts in it, and most of the time, the accusations are filed when a nurse is either a repeated offender. So if there's priors, then an accusation would be more likely to be filed, or if during an incident, say a DUI incident, there are many aggravating circumstances such as a collision, an injury, a very high BAC, statements made to the police that are in the police report that are cause for concern, either indicative of a substance use problem or mental health issues. These are the reoccurring issues that usually spur the board to filing an accusation. In summary, the disclosure process before the Board of Nursing is very important, and we advise anybody in this process to retain counsel so they can best assess their options, which could include entering into the board's diversion program. This program is essentially a way to avoid formal discipline if you are able to comply with the terms and agreements of the program. It's approved by the board. More information can be found on the BRN's website. This is another thing that we help many people determine whether or not it's the suitable option for them, or if they wish to proceed in a different manner.